Good morning, members. We have reached the appointed hour, 10:45, and we have a quorum. The meeting is now called to order. Agenda item number 1, confirmation of minutes held on the 4th of February 2013. The minutes have been sent to members. The Secretary has not received any proposed amendments so far. So shall we confirm the minutes, please? Thank you very much. Let's invite the officials into the meeting room. According to the requirement of the Secretary or Secretariat, I declare interest. I'm an accountant, and the company which I work for has does provide taxation advice, including the area covered by this bill, and I also own property. Do other members want to declare interest? I have already spoken on that, and I just repeat it. Mr. James Tian. Yes, I follow what I've said before. I repeat what I've said before. Ms. Emily Lau. I own property. Mr. Leung, Andrew Leung. I own property. Sorry, speaker's not coming through. Mr. Alan Leung. Speaker not coming through. Mr. Wong Ting Kwong. Speaker not coming through. Mr. Chen Kam Lam. Mr. Poon Siu Ping. Speaker not coming through. Ms. Ann Cheng. I declare interest. I own property. Mr. Lam Tai Fai. Mr. Speaker not coming through. Okay, the Secretary will follow up. They just repeat what they have declared in the past. Since the last meeting, we've issued a letter to the administration, and that includes the questions raised by members at the meeting, asking for the administration's reply. And the administration has replied, and they are paper number 1843, 1213, 01, and also 02. So would the administration take us through the papers, please? The first paper is CB1 1843 1213 02. This is the response to the issues raised at the meeting of the Bills Committee, and that includes a proposal to exempt companies owned by Hong Kong permanent residents from the BSD, and that includes making declaration in a personal capacity and making a declaration in the capacity of a shareholder. And the second part is in relation to exemption given to Section 88 organizations. We've also provided information on matters relating to Section 88, and also finally whether the stamp duty or the SSD and BSD are constitutional. And the other paper is in respect of actual examples of giving exemptions leading to evasion, or that is in response to Mr. Abraham SHEK's request. Madam Chairman, shall I take members through the paper? I believe members have read the paper. At our previous meeting, we've agreed that today's meeting should be the beginning of the clause-by-clause study of the bill. Members raised questions, and the administration has responded. So I allow members to ask their questions or make their points, but please do not repeat what you have said already. And if the points are just similar, and then at the end of the day, members may just hold a different view with the administration, and neither side can convince the other. Ms. Andrew Leung, my question may not be answered within 5 minutes, but I continue to ask the question. I'm not filibustering. With regard to the two papers, the administration says that the proposals made by us have many loopholes. and there can be evasion of stamp duty, and purchase and sale can be executed even if there is no stamp duty. Now, the administration has not received Mr. Abraham SHEK's proposed amendments. In fact, Mr. SHEK proposes to pay the BSD first and then have reimbursement later. So there is no loophole. The tax is paid first. You really can't start up 200 companies to speculate on property. But if somebody does that, one is really out of one's mind in the current economic situation. Now, there are so many loopholes, as said by the administration. In fact, it's all proposed by or raised by the chairman. Now, you say that there is a big loophole, but you have not spelled out what the loophole is. And you also say that the administration may send a wrong message that we are going to normalize that. The point is, Hong Kong people are exempted from BSD if Hong Kong PRs are exempted from BSD if they buy property. But if this person holds any property on behalf of anybody else, he is not against the law. We can have 2 to 3 million people buying property on behalf of foreigners and holding these property on behalf of foreigners. Isn't that a very big loophole? According to the administration, last year, less than 10% of the property transactions were executed in the name of company, in the name of a company. Now, how can you plug the loophole that I buy property on behalf of a foreigner and I don't even need to make a declaration? If a foreigner gives you $2 million to buy a property and he doesn't, and one doesn't, you don't need to make any declaration. You don't even need to make a loan. Now, how can you plug this loophole? In fact, in our paper CB1 1843-02, we do respond to that. The difference between an individual and a company has been stated. Now, to evade property, say if a foreigner wants to dodge BSD, what is the incentive for that foreigner? Say, suppose there is a foreigner who asks a HKPR to buy and hold a property to avoid stamp duty or BSD. As for the individual buyer, one has to declare one is a HKPR, and second, one is acting on one's own behalf. It is easier for the IRD to verify such information. The HKPR has to present his or her HKPR, and the ID states clearly that the person is a HKPR, and the IRD can verify that. If the property is purchased by the individual or in the name of the individual, then one has to pay stamp duty, and holding that stamp duty document, one can register the title of the property. In other words, the one who goes to register the title is the HKPR. If a foreigner wants to make use of the HKPR as a front to buy property, then the foreigner will have to take a very high risk. The HKPR can own that property because on the register, the HKPR is the only owner. The foreigner has a high risk of losing his interest in that property. Will that foreigner, therefore, ask a HKPR to buy property in order to dodge tax? That's very unlikely. Now, if it is bought in the name of a company, the ownership of a company can be transferred behind the scene, and the transfer of shares cannot be easily detected by the IRD, even if a declaration is made. If the transfer of shares cannot be easily discovered, then it is very likely for people to dodge tax in this way. We have already explained that before. The transfer of shares of a company can be done in many ways, and there can also be secret agreements. Apparently, it can still be a company owned by Hong Kong PR who are shareholders, but there can be transfer documents, there can be signing of transfer documents, there can be handing over of company seals. All that can be done without the knowledge of the IRD. The IRD cannot verify all this. Even if there is a declaration, but the declaration cannot be verified easily. And therefore, there may be a high incentive to make such a declaration. As for the purchase of property by the individual, the situation is entirely different. Madam Chairman, if I may follow up, say if I buy a property for another person, and then I sign a loan document, I owe that person $25 million. Or I can do a trust, and I can do it by trust. How can you monitor that? Do you need the buyer to prove the source of fund? Now, in assessing the risk, as said by members, we do not assume everybody wants to evade tax. Now, you assume that because you cannot monitor that. Let the official reply first, please. I want to clarify that we don't mean that everybody in Hong Kong wants to dodge tax. We have to consider the incentive to dodge tax and the risk. And the risk level. If the risk level is high, we should not put that into the law. If the loophole is obvious, we shouldn't put it in the law. If the risk is low, then we will not deliberately make an overkill. Mr. Leung Chi Chang. Thank you, Madam Chairman. I have looked at the amendment proposed by Mr. Abraham SHEK, and I hope the administration will clarify this. He proposes that after 3 years, now he pays the tax first, the stamp duty first, and then after 3 years, if there is no change in shareholding, no transfer of shares, and after 3 years, the stamp duty at the BSD will be reimbursed or refunded to the company. Now, after the proposal has been made for quite some time, it has not been helpful to dampening the property market. Property prices just remain stable, and there are few transactions only. If Mr. SHEK proposes to, or rather, if you, according to Mr. Abraham SHEK's proposal, what is the assessment of the measures? Are these measures effective within 3 years? Now you just dampen the demand for a house for buying property, and you buy time to build more homes and increase supply so as to enable the markets to become to come back to the normal trend. So what is the basis of 3 years? How soon will the property market become normal? Is it 3 years or what?
Thank you. Well, we have said it many times. We don't have a crystal ball, so I can't tell you today whether the property market will resume back to will be back to normal in 3 years' time. Supply is an important factor, but the market is also subject to price changes and other factors. For example, external environment, when the U.S. will increase interest rate, what are the expectations of prospective buyers, and also about the rate of mortgages. Well, this is how I see it. A member proposes amendments with good intentions because they would like to see the measures achieve its goal in 3 years' time. So I'd like to know whether that will be done in 3 years' time. Of course, the property market is not just subject to one factor. The more the supply, the higher the supply, the better. This may not be an ideal amendment, but this will have an impact on when the bill will cease to have an effect. It's kind of like a sunset clause. We've already said that a sunset clause is not appropriate, and we can't tell when is the right time to withdraw it. Of course, if it's no longer needed before the end of 3 years, these measures would have been withdrawn. We cannot set a fixed target of 3 years, and I'd like to say that, of course, the government will identify land for private housing to be built. But that also depends on the inclination of developers, whether they are willing to purchase the land, and after units have been built, when they will be put on sale. And we cannot say for certain when these things will happen. The administration is looking in detail about Ms. Shek's amendments. We will give a response. Well, on the face of it, it seems that there is a timeline of 3 years. But if that is the case, you send out a message that the measures will be withdrawn in 3 years' time. But no one knows whether that will be the case. If you put a fixed target of 3 years to withdraw the measures, maybe people will think, well, I will just make a purchase now, only to wait for 3 years before I get back the refund of my tax, and this in turn will undermine the effectiveness of the bill. Mr. Wong Kok Ping. Madam Chair, I see that there is a news report of a survey done by the Hong Kong CU Institute of Asia Pacific Studies. It says that these measures were supported by 13% of the respondents. This is a demand-side management measure, and that is justified and warranted. But is there room for amendment? There may be room for amendment. In relation to Section 88, charitable organizations exemptions, the administration paper said that the proposed exemption is not acceptable. Paragraph 13 to 15 of the paper. Well, I have some questions. Well, currently there are 7,592 charitable organizations. And according to what is stated in paragraph 14, the government is concerned that granting BSD exemption to charitable organization may stimulate the overall demand for residential properties, which runs contrary to the policy intention of the BSD. I have a question for the administration. You said that it might stimulate the overall demand. Where is your justification? The administration said in the paper that IRD does not oversees their operation, including whether there will be property transactions. But in the bill, what about a requirement of these charitable organizations to make a declaration when there is a property transaction, or ask these organizations to get a proper authorization in accordance with the memorandum, articles of memorandum? I think that there is a certain degree of monitoring of the operation of these charitable organizations. It doesn't mean that if you give them exemptions, they will engage in speculative activities in the property market. If they are found to be engaged in such activities, it will tarnish their reputation and they will not get public support. Have you done any studies, any information showing that charitable organizations have in the past engaged in speculative activities? Any such cases? How many? What is the amount involved and what are the implications? I want the administration to give me the facts and to tell me their analysis of the reasons why such exemptions are not to be given. Yes, I will answer the latter question first, whether we have any information as to whether there is any charitable organizations engaging in speculative activities. We don't have such information. Under Section 88 of the IRO, the IRD exempts profit tax from the profits generated in the carrying out of the charitable objects. They may engage in property transactions, but such profits are subject to profits tax. The IRD under the Section 88 will not get involved in the operations of charitable organizations if they have nothing to do with the charitable object. Under the provisions of, for these Section 88 charitable organizations, when they buy and sell properties, they will have to pay stamp duty. And the only exemption is given when the property is given as a gift. So all along, charitable organizations may engage in property transaction and they have to pay stamp duty. The IRD will not supervise the daily operation of Section 88 charitable organizations, say, for example, the structure of the organization and fundraising activities. These are not under the scope of the IRD. So if we exempt charitable organizations, and according to the information we have, 3/4 of such organizations are registered in the form of companies. So will these organizations engage in speculative activities as a result and in turn stimulate the overall demand? Mr. Wong, I think the argument is really weak. I have been living in Hong Kong for a long time and I've been in politics for over 20 years, and I've never heard or seen any news report about charitable organizations reaping huge profits by engaging in property speculation. So is this assumption wrong? As I said at the beginning, the administration can, in the bill, incorporate requirements that if charitable organizations engage in property transaction, they have to make a declaration of not doing so, that they're not doing so for speculation. Why doesn't the administration consider that? And instead, they assume that all these 7,000 charitable organizations will engage in these shady businesses and assume that they have the intention or the motive to speculate. The assumption or the premise itself is problematic and is unnecessary. Any response? Well, does the administration have any information about charitable organizations engaging in speculative activities? As I've answered, we have no such information. What about the IRD? We don't have such information. Madam Chair, well, if the administration and the IRD do not have such information, then will they consider what I've said today? I earnestly ask the administration to seriously consider assessing whether charitable organizations will have the motive or the incentive to engage in such activities. Will charitable organizations neglect their or put aside their reputation and their social responsibility by engaging in speculative activities? As I reminded members, there was a consensus in the last meeting that we will start our clause by clause today. This was mentioned in the past, but I will still allow members to follow up on to ask follow-up questions on issues raised before. But please be to the point and do not digress. Ms. Ann Chang, I have 3 questions to ask the administration. First, well, it's been almost a year because this is a bill in 2012. In the past year, is there any increase in the number of newly registered companies? And what about property transactions done in the name of companies? Is there an increase? Is there any increase in the percentage? My third question. If this 2012 bill is endorsed, how many people will lose their jobs as a result? Perhaps you can tell members about the number of property transactions in terms of percentage of done in companies before and after the implementation of the measures. We don't have such information. There are about 10% of property transactions done in the name of companies, but I don't have the information reflecting the changes. I'll give the same after the meeting, and I don't have the information off the top of my head about the increase of newly registered companies. What about unemployment in this sector? We're talking about those working in intermediaries. Well, any such information, as you know, that the property agencies are facing a lot of difficulties at the moment. We don't have such information at this stage. Then I ask for them after the meeting. Members, you should bear in mind that the information is given on the basis of what information they have. Mr. James Tien, in reply to a member's question, the administration mentioned about supply. Whether it's 3 years or 2, the goal of the administration is to stabilize the property market and to keep the prices low so that properties will be affordable to the general public. You may release land for developers to build, but you said that it is subject to the general environment and whether developers will put them on sale. This is rather misleading. Do they know about the low unemployment rate in the construction industry? A few years back, there is a very small number of residential units, HOS, PRS, and private housing. What was the unemployment rate and what is the number of employees in the construction sector? And if the number of units to be built is to increase by 50 to 60%, what will be the impact on the industry? How can you say that developers may not put the built units in the market for sale? In the past, it would take 5 years to build a block of flats, and now it would take 6 to 7 years. So why would the administration say that in 3 years the problem will be resolved?
The administration, did you say you can solve the problem within 3 years? Well, we never said we have never said that. We have no crystal ball. We cannot say that after 3 years these harsh measures can be withdrawn. Supply is not entirely in the control of the administration. The private developers build flats in the private market. The administration is to provide suitable sites as many as possible. As for the timing of the construction and the timing of sale, they are not in the hands of the administration. And we've noticed that in the construction industry there is mismatching in the labor market. Now, a government must have policy objectives. These so-called harsh measures seem not to have any target objective. It seems that these measures can stay there for 3 years, 5 years, or even 10 years. The market is not just made up of developers. There are also buyers. Those middle-income families who want to buy homes, and also other buyers. You don't have any policy objective in solving this problem. What is your time frame? What is your objective, policy objective? Whether it is the BSD or the SSD, they are demand management measures. We don't want them to be there forever. They are just for a special situation during this market exuberance. What is meant by this exuberance? What do you mean by that? Mr. Tian, let her answer your question first. Let her speak first, please. My question is, what do they mean by exuberant? Well, it's not just our comment. If you look at the comments by The Economist, it has said that the risk of property bubble is very high in Hong Kong. We don't set a target of reducing property prices by a certain magnitude. We want to stabilize the market. And these measures on their own cannot achieve this objective. We need to work on the supply side as well. And it takes time. And therefore, we cannot say 3 years or what sort of time frame. Or when should we set when should there be a sunset for the bill? When it is appropriate, when the measures are no longer needed, then we will withdraw the measures or we will tone down the measures. And that's why we need to discuss with members. Mr. James here, follow-up. Now, since the administration says that it takes time to produce, to increase supply, this is a proactive government. that this is an executive-led government. If it takes time to increase supply, what is the time frame? What is the time frame? Whether one is an investor or one is a buyer, one needs to know. What is your time frame? Well, I've said that many times before, we cannot make such an estimate. Investors have their own assessment. Mr. Wong Ting Kwong. I want to follow up the question raised by Mr. Wong Kok Hing. In answering Mr. Wong Kok Hing's question, the Deputy Secretary says that stamp duty is exempted if a property is given to a charitable organization as a gift. Under this under the proposed measures, will that be maintained? The answer is the affirmative, Madam Chairman. If some kind-hearted people give their property to the charitable organizations, the act will not be caught by the harsh measures. You're right. Ms. Ellen Lau. A long time ago, on behalf of the Civic Party, I said that we supported the measures of the administration, but the problem is that there will be collateral damages arising from these harsh measures. Now, they exempt BSD for HKPR buying property. Now, if you give exemption, then you have to face the challenge of logic. HKPRs buying property are exempted. Why? A company wholly owned by HKPRs are not exempted. Why? Hong Kong charitable organizations are not exempted. What is your logic for refusing this? The Secretary says that she will respond to Mr. Abraham SHEK's CSA proposals. The Civic Party reserves its right in responding to the administration's response. As for the charitable organizations, on a certain occasion outside this chamber, I raised this question with Mr. Chang Peng Leung, Mr. Anthony Chang, and he seemed not to understand the point. The point is that even if you are under Section 88, you are given blanket exemption, you will not be subject to BSD in all circumstances. But that's not the case. The charitable organizations must have charitable purpose, a charitable purpose or charitable purposes. Whether you run a kindergarten or you run a home for the elderly or you're a church, you own the property for a particular charitable purpose. When you buy a piece of property, you should spell out for what purpose the property is purchased, and you give an undertaking that you will not you will be reimbursed after 5 or 8 years on the BSD page. I think you are familiar with the statement of the Policy Secretary. He said that it would not be contrary to maintaining stability in property market. It would not cause a loophole that cannot be plugged. It would not disseminate false information. It would not disseminate information contrary to the market. Now, having heard, the administration, we are fighting for exemption given to charitable organizations. I use the measures, or rather I use the criteria or the yardstick mentioned by the Policy Secretary. And I ask the officials to do the same and apply the yardstick to the charitable organizations. The purchase of property is only for charitable organization, for charitable purposes. If you apply these the yardstick to that, can the charitable organizations be exempted? Now, concerning the logic, Mr. Leung is right. Concerning BSD, we really want to apply to all business transactions, but there are HKPRs who have the need to buy a home in spite of the present exuberant property market. We therefore exempt the purchaser from BSD if one buys a property in a personal capacity. But if it is a company, it is business. It is doing business. I don't care, or rather, whether it is for capital gain or for investment or for doing business. It's a business. As for charitable organizations, it's said that they have charitable purposes. Say if they buy a piece of property to achieve a certain charitable purpose, should that be exempted? In fact, the law doesn't have a definition for charitable purpose. The IRD just acts according to precedents. It can be education, it can be disaster relief, it can be environmental protection, it can be education. Whether a certain purpose is a charitable purpose is controversial. The BSD is about residential property. Why? A charitable organization wants to buy a piece of property for running a kindergarten or a home for the elderly. And we cannot rule out the possibility that somebody may set up a new charitable organization registered as a company to buy and own property to avoid BSD. If somebody gives a piece of property to a charitable organization as a gift, that gift is still exempted from BSD. That's a suitable balance. We don't want to give too many exemptions so that people can dodge the tax. Thank you. Mr. Ronnie Tong. Madam Chairman, I want to follow that up. Now, I find it for the first time that the administration does not understand the position of members asking for giving exemption to the charitable organizations. If a charitable organization buys a piece of property for the purpose of speculation or investment, the organization should be regulated. But if it is for charitable purposes, then the organization should be exempted because it is for charity. And in fact, the administration, in answering Mr. Leung's question, has not understood the question thoroughly. At present, the exemption, the issue is based on the lease rather than the actual use. For old buildings, in fact, their uses have changed over time. Whether you can define more clearly the term of a residential property, and if an organization buys a piece of property for charitable purpose, that can be done through better drafting of the law. The administration says that there are many kinds of charitable activities, but this is not insurmountable, not an insurmountable problem. I agree that you should combat speculation, and I can reluctantly agree that you can combat investment in property, but I cannot agree with you that you in respect of combating charitable activities. A solicitor who is worth his salt can draft provisions that can achieve this policy objective. You cannot just say that there are too many kinds of charitable activities and therefore you cannot draft a piece of legislation to exempt that from BST. If you don't want to combat the activity of charitable organizations, you should be able to write up a draft that can exempt purely charitable activities and can still catch all the investment and speculative activities. It's a question of the will. If you want to combat the activities of charitable organizations, then of course you will not agree with us. So do you want to combat the charitable organizations?
Of course, the administration does not want to combat the charitable organizations. If it is a gift, there is exemption. And that has always been the case, and it's the same here in this bill. So it shows that we don't aim to combat charitable activities. If that is the case, then you will agree with the proposals of members, and you will go back to revise the wording of your draft to allow charitable organizations to continue with their activities. There is a common ground here. Then why would you reject the idea of an exemption? Well, Mr. Tong mentioned about the instrument, the instrument that will have to be stamped. Mr. Tong also mentioned a valid point. Well, there is a point of contention. It's rather contentious that we do not allow speculative activities. Some charitable organizations said that they use the properties purchased as an investment to collect rent so that the money is used to subsidize other activities. I don't think you understand what I was trying to say. Maybe it's me. We've been saying a lot of things. We've been saying it for a very long time. And it seems the administration still doesn't understand where the problem lies. It's not a matter of how difficult it is, but where the goal is. But we have the same goal. And as I've said, that there are charitable organizations that have bought the properties for investments and not in carrying out its charitable purpose. And if we change anything, then there will be queries. The charitable organizations will have something in mind when they buy a property. The DS has said repeatedly that the bill aims to stabilize the property market, and they will avoid causing disturbance to the public. And they've also said that they will do their best to not give exemptions so that people will abuse them. In reply to Mr. Andrew Leung's question, the DS said that the risk of a foreigner asking a Hong Kong PR to buy a property for him or her is low. What studies have you done to arrive at such a conclusion? Of course, if you ask people whether they will be used as a front to buy a property, of course they will say no. So what survey or studies have you done, and what is the scope? Yes, I'm afraid that we will not be able to do a survey. No one will tell us the truth. What we see is that if it is a property purchased in an individual's name, the foreigner has to take on a huge risk, because the Hong Kong PR may sell the property he is holding, because the Hong Kong PR will register and have the instruments stamped in the name of the Hong Kong PR. So the Hong Kong PR has the beneficial interest. The foreigner will have to bear a risk, the risk of whether the Hong Kong PR will sell the property and take the profit. We think that the foreigner will have to take a high risk. And so in theory, the possibility of someone using this to circumvent the payment of stamp duty is low. Whereas for a company, we know full well that there are many different forms to transfer the interest of the company, and it's difficult to unearth these practices. Since it is well known that such transfer will be difficult to be unearthed and the cost is low, people will have a higher incentive to use this way to circumvent the payment of stamp duty. The DS said that there are many ways for people to use the transfer of company shares to engage in dodgy businesses. Well, we are honest people. We don't do things like that. So when it comes to the change of directors or transfer of shares, if the shareholder is a Hong Kong PR, and if the Hong Kong PR accepts the proposed transfer by a foreigner, the Hong Kong PR will have breached the law. What is your concern? Well, please refer to CB bracket 1184.3.12 to 13 bracket 02 paragraph 5 to 6. There are many ways where shares can be transferred, and even when the transfer is not registered with the company's registry, it doesn't affect the validity of the transfer. And it is difficult to uncover or trace the many ways of share transfer. And as we've said, well, based on the cases that the IRD has encountered, it can be in the form of signing a blank instrument of share transfer and provide all company seals to people outside Hong Kong. So on paper, these people are not shareholders, but in effect they control the company. And in order to plug these loopholes, we will have to introduce a fundamental change of the entire structure of company registration. But we need to consider whether such change is proportionate, bearing in mind that the BSD is an extraordinary measure introduced under exceptional circumstances. We still have two members who would like to ask questions in a second round. These issues have been discussed in the past. If there are no other questions, I'll draw a line here. Then I will ask the administration to take us through the CSA. Second round, Ms. Emily Lau. I said in the early days that the biggest problem is to provide sufficient supply to meet demand. The administration failed to tell members when they will be able to increase supply, because if they manage to do so, there is no need for such measures, because as they've said, this is an extraordinary measure introduced in an exceptional time. If the administration can do something, then they will have a general idea. They talk about a long-term housing strategy. Still, they don't know when they will be able to increase supply to meet residential and commercial demand. Well, the president of the LegCo said that it's a myth. If you talk about executive-led, you will have to tell us very clearly how you plan to supply housing land and when these residential units will be built. But you can't tell us anything. And many weeks ago, when the Bureau Secretary came to the Democratic Party caucus, we said that there are people from the business sector, not just developers, from banks, who said that there is a policy risk. The person said that in the past that is not considered in Hong Kong when one's doing business because there was no need. Well, the policy risk is that the situation may change any time, and that would be risky to make an investment. The Bureau Secretary said that it is an exceptional time, but the business sector don't know what and when will exceptional circumstances be. We're talking about such times for formula milk. When will there be there may be an exceptional time for tissue papers. We want a bit of good business environment in Hong Kong. Are you telling us that it is out of your depth to tell us an answer when you'll be able to come up with sufficient supply to meet demand? I asked the Bureau Secretary the other day, well, do they realize there is concern about in the business sector? I didn't even talk about someone withdrawing investments here. You have a whole team helping you, the EXCO and the civil servants. So you don't even know when the exceptional circumstances will end. Some people support these stringent measures. Of course they do, because property prices have gone through the roof. A lot of people are complaining. What is going on here? These questions should be answered by the Bureau Secretary. When will the exceptional circumstances end? They don't know. You do need the cooperation with the LegCo so that these problems can be resolved with everyone putting in their efforts. But that depends on demand. But we're talking about supply. If there is sufficient supply, the problem will be resolved. But they fail to answer us. Yes, well, we've said that supply is very important. For public housing, we have set goals. Say, for example, 75,000 public housing units, and we've raised it to 79,000 in the coming 5 years. And starting from the 2018, 5 years onwards, we're talking about 150,000. And of course, nowadays there is a higher supply floated. The relevant departments and bureaus are doing their best to identify land. As Ms. La said, we need the cooperation of district councils and the LegCo. In the coming 3 to 4 years, in terms of private housing, there will be about 71,000 units made available. Every year, we will try to find land to provide about 20,000 residential units a year. Of course, we're all working very hard to find land. But we should not forget that there are thorny issues. Say, for example, change of land use for certain lots, increasing plot ratio in others. We encounter difficulties when we consult the districts. And everyone is doing their best. Ms. Lang, just a quick word. I don't see that the administration is doing their best to cooperate with the relevant parties to find land. If you all sit together, lay everything on the table with the LegCo, with the 18 district councils, and you all make commitment to put your heart your hearts into it, the problems will be resolved. But I don't see that. You sit here telling us that this is an exceptional circumstances, and you can't tell us when it will end. This is blatant incompetence on the part of the administration. It makes the blood of the public boil. Mr. James told. Well, I've mentioned this before. If you use a Hong Kong PR to circumvent the duty and the relative risk of using a company as the front, the administration said in paragraphs 8 and 9 that for using a Hong Kong PR as a front, the risk is high. And in paragraph 9, it says that the transfer of the company shares from Hong Kong PR shareholders is the relevant risk is low because it's easy to take control of the company. This is problematic.
Say in paragraph 8, concerning secret agreements signed, the secret agreement cannot be registered with the land registry because it is not stamped. By the same token, if they sign a blank transfer instrument, somebody has to put down his name, and then goes to register with the company registry. If that transfer document is not stamped, then it will not be effective. Is it the case? If that is the case, then why the risk is lower in respect of the transfer of shares in the company? This is the first question. Yes, the Deputy Secretary. I asked my colleague to answer the question. Now, concerning Mr. To's question, the Deputy Secretary has already explained that. And she has also explained the difference in risk levels, if I may add. If it is an individual buyer, or rather, if a foreigner owns a property through a Hong Kong PR, as said in the paper, they have to reach a secret agreement. The beneficial interest is transferred by that secret agreement to the foreigner. But since this secret agreement is not registered with the land registry, the Hong Kong PR who has bought the property from the front is not aware of the secret agreement, and when he goes to register the property, he is regarded as a bona fide owner, and the foreigner therefore cannot rely on the secret agreement to get back that piece of property. Under such circumstances, the foreigner is very unlikely to make such a secret agreement in order to own a property in Hong Kong. The foreigner can only go after the Hong Kong PR who has entered into the secret agreement. And that HKPR might have already absconded. The chance of recovering the property is very unlikely. Therefore, the risk is high. I think the chairman is frowning. Chairman, Mr. To, do you want to follow up? The question is a comparison. Why the risk of owning the property through a company is low? They can also sign the documents. Now, if the company is wholly owned by HKPRs, they can sign blank transfer forms they can give the seals, all the seals of the company to the foreigner. Mrs. Kwok, if you don't understand, ask the experts to answer the question. My apologies. If you say just by signing a blank form and that is permanent guarantee, then they can sell the property. After they sign the blank form, they can sell the property to the chairman. Let's be frank. This is on the technical level. I analyze it on the technical level. You can't just read out your official answer. If you don't understand, get the experts to answer the question. Mrs. Kwok, you are the AO. You are not responsible for doing the transfers or making the stamps. You can even ask the CCB to come and answer the question. What's the use of signing a blank form? The property can still be sold. If it is not stamped, the property can still be sold. The judge will not entertain your claim because you have not stamped the title document. Get the experts to answer the question. Don't just give us specious arguments. Who is to answer the question, Mrs. Kwok? We've already put it down very clearly in the paper. It's not just a specious argument. The foreigner can be the authorized signature, can be authorized to use the bank accounts and therefore can control the company. The question is whether the foreigner can control the company and get the beneficial interest. The actual person, the actual control is in the hands of the HKPR. He can sign any form. I've done such a case. It involves hundreds of millions of dollars. You're just telling fairy tales. Do you say that if just signing a blank form and then giving a blank form to the foreigner, then the Hong Kong PR cannot sell the property? Can't the HKPR change the seals, change the bank accounts? Of course, the HKPR can. The third party, and in fact, the property can be sold even if it is occupied. You cannot say that the risk of transfer by company is low. You're just intellectually dishonest. We have not said that there is no risk with the individual. Now, there are many ways to transfer the company. We are not as an expert as Mr. To. We just want to spell out that there is a high risk of tax dodging by the companies. If you control 5 shareholders, if they cannot have disputes, it will be more difficult to avoid to control a company with 5 shareholders than controlling an individual. Although I've drawn the line, but there are members who want to speak, so I give 3 minutes to each member. Please be precise and concise. Mr. Leung, I was attending the Select Committee on Timothy Tong. Is it the start of clause by clause? Are we going to start clause by clause study today? Yes. So I don't ask any question now. Mr. Andrew Leung. In fact, the administration in answering Mr. James Tian's question is rather dodgy. The Deputy Secretary mentioned short-term measures, and then she switched to exceptional circumstances and exceptional measures. And then she was asked whether it was 3 years. She said she didn't know, she didn't have a crystal ball. What is your time frame with regard to your measures? You say it's demand management. It is not demand management, it's suppressing demand. But that is the demand. There is always the demand. If it is a short term, 2 or 3 years, okay, we can tolerate that. But your exceptional circumstances and exceptional measures do not have a time frame. And you don't tell us what is your time horizon. When you say there is enough supply, you will withdraw the measures. But Mr. James Tan said that without 5 or 10 years, you can't have enough supply. According to your long-term housing strategy, you don't have enough land. The measures may be for 10 years. You shouldn't cheat. Property prices will not go down. The government's policy is to keep property prices up. Last year, it was about $5,000 per square foot on average. This year, it will be much higher, maybe $7,500 per square foot. You shouldn't give people the belief that property prices will fall to, say, on average, $7,000 per square foot. After 5 years, it may be $13,000 or $14,000 per square foot. Now, the SMEs need to borrow. Let's don't talk about the real estate agents. The decline in a number of real estate agents, and a lot of people have become unemployed. Just the SMEs, they need to borrow from the banks. What is your time frame? In answering Mr. James Tan's question, you've made reference to 3 time frame: short-term measures, exceptional circumstances. You are unable to come up with an exact time frame. The business sector and the general public have demand for property. You just say that exceptional, and after the speculation has been suppressed, people will be able to buy property. It's just a fairy tale. Is there a time frame, the Deputy Secretary? No, we can't give a time frame. That's why we cannot accept a sunsetting clause or for how many years we are going to keep these measures. We will make adjustments accordingly and suitably. That's only I can say. Mr. Jeffrey Lam, I declare interest. I myself and some of the companies of which I am a director do own property in Hong Kong. Mr. James Toh, I own property with my wife, a property with my wife. Para 9. That cannot be discovered or traced. If it is easy for the IOD to ascertain or trace, if you give your bank account to somebody else, the IOD can trace. Blank forms cannot be traced. But if it is in breach of the law, how can people control that? The Hong Kong PR can sell the property to somebody else, even it's owned by a company. Then the blank form cannot. The blank form has not been stamped. The seals can be changed. Say the one who has entered into a secret agreement, he can make another seal. Pay $10. Half a day, you get a new company seal. You really don't understand. Now you say if you get a HKPR to buy property for you, that's high risk. But he can keep the key. He can live there. He can get an authorization, and then he can let it out. He can let it out. He can get the rent, and he doesn't need to register at all. He doesn't need to register at all. So it's still high risk. The question is just how many people do you need to control, one people or many people. The risk in terms of the difference in risk is just marginal. The signature, the seals, the blank forms, it seems there is a lot of protection, but that is not. They can all be done again, all over again. Now, just if the blank form is not stamped, can it be put before the court as evidence?
Who is to take this question? Well, according to our understanding, if someone wants to use a company to, say, circumvent the BSD, I believe that they will approach or set up a company, approach a company or a company that is specially set up for this purpose, instead of going to a company with 4 or 5 directors or with complicated issues. In relation to the blank forms, it depends on when they are needed. If they want it, then they would just put on a date, fill it in, and have it stamped. As long as it is stamped and it is valid. So without when it's not stamped, then it is not valid. When they need the document to prove that they are the shareholders, then they will have it stamped. Well, what about when the shares have been transferred and the document is stamped? Does it mean that it is valid? Well, if someone is using such companies for such activities, they will approach specialist companies. And under such circumstances, the company will not sell their shares to someone else. Well, I think the IRD is outrageous because they can tell me which is easier, to find a special company or to find someone out of 7 million people. Of course, it will be easy to find a dedicated company set up specially for this purpose, rather than having to find a culprit among 7 million people. The BSD can be circumvented by using a Hong Kong PR. So you're saying that there are companies specially set up for this purpose. So does it mean that the IRD has already had its eyes on certain companies? IRD, are there such companies? Well, there are cases in which companies are used as a front to carry out specific businesses for someone else. Yes. Then compare this with the number of people out of 7 million who are willing to do such things. Well, these issues have been discussed before. I do have to ask this question. I have doubts about what Mr. Tam said, and I would like to ask some questions. This is a bill. I want to ensure that everyone has sufficient time to discuss all matters. But these questions may be raised again when we come to clause by clause. So don't think that if you don't have a chance to ask questions, so you won't have a chance to ask later. Mr. Leung. No, it's not about the clause by clause. Mr. Tam said that using specially set up companies to circumvent the payment of tax involves smaller risk. Well, if we use an already established companies, the company that is already doing business, well, what about the risk? And if there is a difference, we can propose further amendments to address that. Yes. Just now, Mr. Tan said that in his experience, there are companies specially set up for a specific purpose. But other companies may use similar ways to circumvent the BSD. It's difficult to define a specially set up company. It may be an ordinary company who just takes it up on the sideline. But if we know that there is a possibility, do we put that in, knowing full well that it exists? Well, there may be 5 shareholders in these dodgy companies. And if they give declarations and guarantee that there is no change in 5 years, is it any different from a Hong Kong PR or a company with just one person? Mr. Lam mentioned about normal companies, and you say that all 5 shareholders turn to dodgy businesses and they all give a declaration. Then, well, anyone out of 7 million people can do that. Well, we shouldn't say that anyone's doing any carrying out any dodgy businesses. We've said that this is to address the needs to purchase a home. Well, Mr. To, you already said that there are many different ways to achieve this purpose. And if we know full well that there are such possibilities, do we still go ahead? We didn't have any exemptions in mind, but we know that there is a need for property purchase, a genuine need to purchase a home. That's why we grant exemptions. We have to go back to the original purpose of the bill. Ms. An Chang. Well, some members have been, some members get bogged down on certain issues. I think it's a matter of perspective. Liabilities are different between a purchase made by an individual and one made by a company. Mr. To talks about 5 people against 1. And if one is bent on doing such a thing, of course that they will set up a company with only 1 shareholder instead of 5. We fully understand it. The business sector fully understands it. But the administration should review the entire matter. Will this affect property prices in Hong Kong and in turn the economic situation here? Madam Chair, you have mentioned many times that we need to go into clause by clause, and it's past 12. Well, I've drawn a line. Let's stop here with the questioning, because these issues have been mentioned many times, and you have an opportunity to raise these issues again in clause by clause. Now we move on to clause by clause. The administration has given us the CSA in relation to the refund and the refund of the BSD and exemptions involving non-Hong Kong PR buying a replacement purchase and other issues. And I'd like to ask the administration to give us information on the general directions before we engage in clause by clause. Well, you'll find the administration's CSA in CB bracket 11719/12 to 13 bracket 01. It covers a number of issues. We've had discussions with members. The first one is in relation to the revised mechanism to refund the BSD for redevelopment projects. We've heard from members and taken their views on board. Now we propose a CSA. When it comes to refund of BSD for redevelopment projects, it's based on 2 principles. First, that the developer is the owner of the entire lot to be redeveloped, and there is evidence showing that the lot will be used for redevelopment purpose. And what is evidence? We proposed 2 options. First, either the developer has obtained from the building authority the consent to commence any foundation work for the lot, or option 2 or option B, that either the building existing on the lot is demolished, other than a building the demolition of which is prohibited under any ordinance. and the developer has obtained the approval of the building authority in respect of the general building plan for the redevelopment. So these two options are available for the developer to choose from. And if they provide proof that the site will be used for redevelopment purpose, the BSD will be refunded. Compared to the previous proposal of obtaining the first occupation permit, the developer will be able to put forward to get the refund by 4 to 5 years earlier. In relation to the general direction, any questions? Mr. James Toh. Well, this is redevelopment. Well, I'd like to declare interest. I'm the non-executive director of the URA. The two options. Is it either or? When you talk about A and B, you mean A and B on the paper? Yes, 1719. A and B are the two options. They are in relation to the provision of proof that the developer will use the site for redevelopment. I'm not very familiar with, more familiar with this than the architects. Is it the case that B will happen earlier than A, or under no circumstances will B take place before A? I think it depends on the lot. As to the time sequence, I'm not able to give you the information now. Well, I just wonder whether A is redundant. Only B suffices. For B to demolish any building, if any. Well, if you obtain the general building plan, it will be earlier than the foundation work consent. Well, perhaps on the lot, the existing buildings have already been demolished. Then there is no need for B1. Then B2 is always earlier than A. Nope, for A, it may be the case when there is no building no building on the lot. No, well, there is no building, then it will be B2. So is B2 always earlier than A? If that is the case, you only need B2. Well, for B, you require both 1 and 2. Well, then you can simply say buildings, if any. And if B2 is earlier than A under all circumstances, then you don't need A. I'm not as familiar with this as people in public works. Can you ask, is B2 always earlier than A? If that is the case, for B1 you say if any. Then you don't need A. Unless you say that, well, there are cases when you don't need general building plan before you get when you get the consent to foundation work. Can you find more information for us before you revert back to us? Yes. And I think you have already taken into consideration actual situations. Yes, for that, to put it forward by 4 to 5 years is good. But if B2 is always earlier than A, then there is no need for A. Are there cases when one doesn't need general building plan in the application for the consent to commence foundation work? Let me look into it. I remember that when we were discussing with the relevant departments, there may be different approaches. And any other questions in relation to redevelopment? If not, administration, please move on to paragraphs 5 and the rest. Mr. Toh. After developer has become the owner of the entire lot. So you mean one owner of the entire lot. What if there are a multiple of owners, but they have signed a development agreement or joint venture agreement? Then they proceed to make applications for A or B2. Would that do? Yes. DS? That would do? Yes. Then the developer has become the owner. May be subject to many different interpretations, some rather complicated. Is that right? DS, anything to add? Perhaps the singular and plural of the words may sign an agreement, and they're all developers. They may want to get a refund early and sign an agreement. Say, I sign an agreement and then rescind it in 3 days so that I can get the refund of the BSD. Is there any chance of an abuse? If you go into the detail of the provision of the clause, it's not necessarily just one single developer. Well, the associated body corporate under Section 45. If you look at the relevant provision, what is an applicant? It refers to the associated body corporate becoming the joint owners of the lot. What is the difference between 2 and 3? Well, for 3, it's built because there is an OP. I'm talking about paragraph 3. If it's 2, you obtain the consent or the general building plan. Well, the cost is low. If the BSD is high, is there a chance that in the end these owners cannot agree, so they want to get the refund of the BSD? They sign a joint venture and just have a plan prepared to get the refund of the BSD, and then they just leave the site idle. Is there a possibility? Well, now you will weigh up the risks of what is going to happen.
The original provision is based on the occupation permit, and we see the building. We must see the building first, but we don't want to impede redevelopment. Since they have already taken this step, it is very likely that they will continue with rebuilding. In our original proposal, one still has to be the owner, a sole owner of the lot. Now we want to incorporate your view. We don't need to see the first building completed and the possession of the first occupation permit. So we advance the time frame a bit. Since the building has been demolished and has got the approval of building plan, it's very clear that there is intention to put up the blocks. And if they conduct any foundation work, say for example, then that is also the proof of intention. That is a suitable balance. Yes, we don't want them to suppress redevelopment. Now, you want it to be a real redevelopment. One may not just require the condition of paragraph 3, the occupation permit, but the conditions in paragraph 2 do have some risk. I'm not familiar with the building procedures. Say, would you say consider the amount of tax to be refunded? Say if they have put in the money into a cost of no return, they put the money in, they put part of the money in, and they really can't change course, then you will refund their tax. Otherwise, they may just drop a plan and apply for consent and get the tax refund and then leave the land idle. Would you consider such measures so that people cannot get through the loophole provided under A and B? With regard to the redevelopment, what has to be done is very different from lot to lot. Now, Mr. To's concern is that the refund may be very big, so that people just do something on paper to get the refund instead of putting up the new blocks. Now, according to our understanding, if they have gone through the procedures as described by A or B, then it's very unlikely that they will quit the redevelopment. I think the safest, of course, is paragraph 3, the first occupation permit. Well, it can be between para 2 and 3, somewhere between the proposals in para 2 and 3. I don't know whether you've considered that. Now, when we drew up the plan, when we drew up this amendment, we asked what constituted what constituted adequate evidence that the developer would go ahead with the redevelopment. And we have come up with these. Mr. To's concern is that somebody may try to meet one of your requirements in order to obtain the refund, and finally does not go ahead with the redevelopment. Are there any penalties if they don't go ahead with any redevelopment? Well, at present there is none. What is meant by redevelopment within a reasonable time frame depends very much on the condition of each lot or each site. Say there may be unforeseen ground conditions, say a cave-in underground, which is not known beforehand. The question is just whether the justification is acceptable or not. Mr. Tony Chair, I have to declare interest. I own property, and I also have a property consultant company which may participate in property transactions. I think Mr. James To has asked whether people try to get the tax refund and therefore they apply for, they file in plans for approval, or they go on with foundation work. Now let's consider the possibility. If you have bought the whole lot and just leave the land idle simply to and do something simply to get the refund, which is 15%, that's very unlikely because it's very costly to hold that piece of land. You just consider interest cost. I come across some example why the redevelopment has been delayed. It is because the developer wants to buy the lot, wants to buy the adjacent lot. Therefore, the redevelopment has been delayed. My question is that if there is a transfer of ownership, do you still allow exemption of the BSD or refund of BSD? Yes, it's very unlikely that having gone through these steps, the developer has decided not to redevelop the site. Mr. To has raised this concern. The Deputy Secretary, would you answer Mr. Chair's question? Now, say same lot, it has got the refund, and for one reason or another, it doesn't proceed with the redevelopment and it transfers the site. Will that BSD be exempted? Would the second BSD be exempted? Will the new buyer be able to enjoy the exemption. Say for one reason or other, the developer doesn't want to develop the site and sells the site to another developer. Will there still be a BSD exemption then? Is my understanding correct? Yes, exactly. Perhaps the IRD can respond. The new buyer, if the new buyer complies with the conditions, then he can still be exempted. Mr. James Doe, I hope you really consider what you are saying. I still have time, Mr. Chair. You want the developer to go ahead with redevelopment quickly. If there is a change in market situation, things may change. Now, if this developer has been given or has applied for refund, then he must have the intention to redevelop the site, and therefore we should not allow the new buyer to get exemption. This will avoid the worry raised by Mr. Toh, or reduce the worry. Reduce the worry raised by Mr. Toh. I think that's very unlikely. But as for the same lot, if it is transferred within a short period of time, then the BSD should not be exempted for the new buyer. That's reasonable. Yes, we'll go back and think about it. Mr. James Toh. The reply by the IRD, therefore, is really shocking. Say a developer has gone through the procedures, he has done A or B and has got the refund, and he transfers the site to B developer. And then B developer says that I have owned the lot and I'm going to conduct redevelopment, and I don't like A's general building plan. I draw up a new general building plan, and then I'll get back the 15%. So the sale of the lots will be exempted from BSD. That interpretation is rather strange. Give us a thorough paper to answer this question. Yes, the Secretary said that she would go back and think about it. Ms. Andrew Leung. Well, Chairman, if I may continue with my point of view. Now, somebody may do A or B in order to get refund. Now, there are companies buying up old properties. Now, say Exxon company buys old property, and it of course can proceed with the development, but it rarely does so. You know that the name of that company. You know that, in fact, now he wants to have liquidity. You may say that buying up old property facilitates redevelopment, but he draws up a building plan, go to an architectural firm, get a building plan, and then apply for that. Get in a building, submit a general building plan for approval, just for the purpose of getting back the fund, the tax. And then at the same time, he's looking for a developer to buy the site. If you want the first one to get the refund, should that be A or B, or condition A or condition B? If the difference are out of proportion, then they will go ahead with this kind of transfer. You really need to do something more, or impose more requirements between occupation permits and conditions 2A or 2B. Just try to make sure that they don't have any money to make just by the transfer of the site and also get back the BSC.
Well, there are 1 and 2 under B that the building has to be demolished and the general building plan will have to be obtained. We understand that for the company, or just for redevelopment, and if the building is to be demolished, then they do have the intention to redevelop the site. So A and 1 and 2 will have to be met. Well, for the development, for the demolition, it incurs cost. But if the benefit reaped can be higher than that, of course, that they will proceed with the demolition. They may not have the intention to redevelop. They just want the site to lay idle. Then, as a result, the supply will not increase, and it runs counter to the policy objective. Mr. Andrew, the administration needs to consider this. You may not be able to give me an answer now. The building is demolished, and thus land is sold. Is it covered by this bill? Think carefully before you answer, because you don't need to pay duty in the sale of a piece of land. Say, for example, I sold a piece of land. There is no need to pay BSD. And under the bill, it says the stamp duty is only in relation to sale and purchase of residential property. So please think very carefully what this is all about. I don't know whether your answer will be accurate, but I ask you to think carefully. We need to know exactly what's involved. As far as I know, if you are involved in a transaction of a piece of land, you don't need to pay duty with the government. Well, if I sell a piece of land to Mr. Tong, does it involve duty? You have to look into it. So if the building is demolished, is it treated as a transaction of land? In relation to the SSD, residential property is defined as if the piece of land is zoned as residential, then it's subject to duty unless it is the first transaction involving the government. Yes. Yes. A BSD applies if it's a land transaction with any developer. Mr. Toh says that a building plan is submitted. I think, well, it's not really the case. Yes, the cost of submitting a plan may be low, but still there are many considerations on the part of the developer. What Mr. Toh said is what Mr. Toh. If Mr. Toh can answer my question, then he will be in the government. I need an answer from the administration, because Mr. Toh will not be held responsible for what he said in reply. I want an answer from the administration. I want it on the record. Yes. I remember in an earlier meeting, I answered this in response to Mr. James Toh, that for government land sale there is no BSD, but if one developer is engaged in a land transaction with another developer, then it's subject to the BSD. Well, members have raised certain issues, and they would like the administration to look into it before coming back to us. Now I ask the administration to continue with the CSA. Mr. Toh, you said the developer has become the owner. You said that the one approaching you to get a refund of the BSD may be a multiple of owners. So you need to prove that all these companies, 100% of the shares are controlled by one party. It's only then when you will consider that it's one single owner. Or is it the case that it's everyone who own the site make an application to you as one? It says that it is jointly or separate, alone or jointly with the associated body corporate making an application under section 45(2). The parent company may own 90% or more of control of the share of the company. Then the associated body corporates can become co-owners of the lot. It doesn't mean companies providing services. I don't understand. For BSD, when it comes to companies, it's so harsh that there should not be any exemptions given to companies. But when it comes to refund, as long as you hold 90% of the control, then you will be able to get a refund. Well, when you are collecting title, it's not done in the name of developers. They use other companies, intermediaries. I mean, intermediaries may be other companies, and these are not included in this bill. We are talking about associated body corporate. That is the control. Over 90% of the control is in the hands of someone else. And under that, we accept them as co-owners. Associated body corporate is clearly defined in the provisions. That is the control of 90% or more. And associated body corporate is under regulation of the company's ordinance. Well, you refuse to relax certain principles, so I will talk principles with you. You said 90%, but it may not be in relation to the redevelopment. Why is a refund allowed? But you need to prove that A or B are met. So whether it's 10% or 90% of shareholders is nothing to do with that. There are steps. First, you have to prove that you own the entire lot. And that is related to ownership alone or ownership jointly with associated body corporate. And the second step is that there is evidence showing that the land will be for redevelopment. So why is there a magic line of 90%? As long as I fulfill the requirements in paragraph 2, then it shows that I have the intention for the redevelopment. All I need is 51%. Why 90%? Why? Then we have to go back to the policy intent of redevelopment. Well, according to members and the sector, that collecting title is collecting title takes time, and you have to sacrifice certain interests. The usual approach of the sector is to use associated body corporate to collect title, and we accept that. That's why we say it can only be associated body corporate. But why 90? Why 90%? It's nothing to do with compulsory sale. No, that is nothing to do with that. 90% is in relation to the definition of associated body corporate. That is also stated in the relevant provisions, not newly added. No. Why does 90% has to be applied in the refund? Can you give me some background information? We're talking about exemption of BSD. Yes. But where does it appear in other taxation ordinances? It's Section 45(2) of the IRO. So, well, is it a suitable proportion or ratio in relation to a refund? Are there any previous cases, and whether the application of the same here is suitable? Well, please give us some more information about redevelopment. Members have raised a number of issues. In the next meeting, we will continue with this paper. Then we will move on to clause by clause. Let me remind members that Mr. Andrew Leung and Mr. Abraham SHEK have submitted CSAs. You have the relevant documents. When we finish with the clause by clause, I will ask Mr. Abraham SHEK and Mr. Andrew Leung to take us through their CSAs. I ask the administration to prepare responses to their CSAs, preferably in written form, because we don't have it today. I hope you'll be able to give us your responses to members' CSA as soon as possible, because members would like to consider the CSAs of members and the administration's responses. Let me remind you, members, that the next meeting will take place on the 15th at 4:30. Please pencil it in. Thank you very much. Meeting adjourned.